This segment was designed to give everyone a break from thinking about alimony for a little while. So we're going to spend the next half hour talking about child support. This session is going to be without a colorful PowerPoint show, but on the bright side, it gives everybody an opportunity to check their email before lunch. Anybody who wants a recap of how the heck Nevada's child support rules got to where they are today may find a fairly easy read in the materials, which will bring you from the pre-1987 era, which we call the gunfight at the OK Corral days, through the 1985 Governor's Commission, the original child support legislation, the 92 and 96 Child Support Statute Review Committee reports, and then the various legislative proxyisms that led eventually to the current regulations and the current Child Support Commission. As the Grateful Dead once observed, what a long, strange trip it's been. To switch metaphors, the history of child support statutory and case law in Nevada has a little bit of the Groundhog Day to it. If you actually study it end to end, the same disputes, concerns, and competing policy directives of predictability, adequacy, and fairness have surfaced over and over for 4 decades. One question is whether collectively we are actually doing any better in balancing their concerns today than we ever were. That's a question I'm going to leave to history. I don't know that we're doing it any better than our predecessors. I'm hoping that we are, and I'm hoping our successors will do it better than we are doing it today. It's going to sound a little quaint to some of the younger members of this audience, but at one point, our child support laws tried to distinguish the real primary custodian on the presumption that there had to be one. Joint custody existed in the real world, but it didn't exist in our child support statutory framework. And we didn't actually have an explicit preference for joint physical custody explicitly until 2015. Our child support case law in the 1980s focused on the reality that just because one parent's expenses increased did not mean that the other parent's income decreased, or expenses, decreased. Our Supreme Court was concerned with the possibility that children don't suffer in the care of the primary custodian by reason of an unwarranted reduction in formula payments being made by the secondary custodian. Again, the early case law was concerned with there being somebody who had that role for child support purposes. Those cases were a shadow of the pre-child support statute world in which some judges were remarkably reluctant to provide child support awards adequate in any way to actually provide meaningful assistance in raising children. You know, every now and again, I hear people complaining about family court, and it's mainly people that didn't have experience in the era before family court, when you would have a judge who would like to do virtually anything other than hear a family law matter. Some of those judges were cavalier in terms of support in the era before a child support statute. And they did whatever seemed like a good idea on a whim. So be careful if you're complaining about the current situation, unless you have the experience to know what we came from to get here. The studies have repeatedly shown that kids are expensive in terms of the expenditure made on children in intact families. And it was those studies that formed the basis for the child support formulas throughout the United States. And there were 6 or 7 major formulas that distributed around the country. Part of the goal of the original Nevada statutory law, and it was in the Governor's Commission in 85, and it was part of the legislative history in 87, was to emulate, model, the level of expenditure of an intact family in a post-breakup family. But there's no real solid evidence that that intention has ever been realized. Cases abound in which parties claim that the awards made by judges either fall very short of or sometimes exceed the level of expenditure actually related to the children's needs and what would have been spent on them in an intact home. that remains a model, a purpose for what child support was intended to accomplish. As a matter of litigation, we had a couple of decades where lawyers appeared to be fixated on labels because of the perception and sometimes the reality that the title of joint custody could defeat a child support increase motion. That went on till 1998 when we got to the Wright versus Osborne offset case. And we finally had a formulaic approach for joint custody cases. In those days, if you go back to the case law, or if you go back to the literature, you'll see that a lot of those joint custody cases were called 50-50 cases, because the presumption was that if you had 50-50 custody, you had joint custody, and anything else was to be titled something else. You can flash forward from 98 all the way to 2009 in Rivero, where the Nevada Supreme Court finally said, look, a 5-2 timeshare just is not joint custody. But we also got some direction in Rivero, and possibly as a reaction to an Ely video skit, and yes, I'm thinking of you, Ray Oster, not to count hours in determining custodial time. The question, of course, if you're not counting hours, is what you're supposed to count. It has proven difficult to mathematically compute responsibility in the real world. At the end of the day, post-Rivero, we had a bright line definition, changing the definition of joint custody from 50-50 to 60-40 or closer. This had a lot of ramifications, the most obvious of which was to permit child support for the very first time in Nevada to flow uphill from the greater timeshare parent to the lesser timeshare parent, if the greater timeshare parent had a higher income. In the decades since then, some national commentary has questioned whether this is really a good idea as a theoretical matter. For what it's worth, I side with the commentators who say that if it's in the best interest of the child to be served by such an order, it's justified regardless of the theoretical discomfiture of child support flowing uphill. If we were in person, I'd take a poll of the audience, but one question for the family law bar is whether the bar and bench, believe that Bluestein's blurring of Rivero's 40% bright line test survived the later embodiment of the Rivero bright line in the statute. I've heard judges say things on both sides. I've heard lawyers say things on both sides, and I simply don't know. It probably awaits a definitive case on point to find out whether Bluestein remains good law or has been effectively statutorily overruled. In any event, the world of child support changed enormously as of February 2020, when the core child support statutes were replaced by administrative regulations set out at Nevada Administrative Code Section 425. Lots of things happened immediately. For example, the 10% per annum penalty for delinquent child support simply went away. The penalty, for those that don't know, was created as an incentive to motivate child support obligors to actually pay support when it was due. But the welfare departments never liked the penalty, mainly because, in my opinion, their legacy computer system, Nomads, was incapable of properly computing it. The rationalization for its elimination was that for a subset of the population, it created a disincentive to paying support. The reasoning was that they got so upside down, they simply gave up and stopped even trying to pay support. So to get them to not do that, we're going to get rid of the penalty so that less money is owed. Frankly, I never bought that explanation, but that view prevailed. And today, child support penalties only exist for arrearages that accrued prior to February of 2020. On some topics, the new regulations didn't so much alter the prior statutory and case law relating to the relationship between custody and child support as attempt to restate it. For example, the regulations made explicit what the prior case law had eventually somewhat stated. If the parties have joint physical custody of at least one child, each party is an obligor. That makes theoretical sense, but the cases seem to have difficulty getting to that point in the 2 decades before the regulations were enacted. The regulations explicitly dealt with joint custody situation by codifying the Wright versus Osborne offset, which previously had been simply a matter of case law. And the regulations provided a straightforward and pretty easy methodology for dealing with split custody. So each party is treated as an obligor of the children in the primary or joint custody of the other party prior to the Wright offset. Right now, the commission is thinking about taking all of those offsets and cutting them in half. In other words, offsets would be 1/2 of the amount of the difference between party A's obligation to B and B's obligation to A. No decision on that, to the best of my knowledge, has been made on that proposal as of today. If adopted, the proposal would lower child support orders in every offset situation. It would also have the effect, from my review of the literature, of breaking Nevada away from the way offsets are done in pretty much every other state in the United States that has an offset provision. Also relevant to our child support statutes is the reality of childcare, which issue has its own weird evolution. It started out in the original legislation and then finally the statutes as a deviation factor for alteration of otherwise applicable child support. This is one of those Groundhog Day items I was talking about. The child support statute review committees in 92 and 96 recommended repeatedly breaking out childcare as a separate item to be separately addressed in every child support order. The current regulations finally broke it out, but the regulations in their original form remain unclear as to what courts are supposed to do with childcare expenses. It has to be separately considered, but it doesn't tell courts whether to add it, address it separately, make it a modification of the other amount, or do something else. It is possible that we're going to get clarification of the regulations on that point sometime this year. The materials delve into the history of some of the theoretical underpinnings of the Wisconsin model child support scheme. And for those that just weren't around in the 80s, Nevada is a Wisconsin model state. We are a percentage of income of obligor only state. And that's the Wisconsin guideline model. And that was the Wisconsin model was the model for Nevada's child support statutes. The short version in terms of the model is that our child support statutes never really were designed to provide support that was actually the same that was thought to be spent in an intact household. And the question that was asked from the very beginning is, well, why not? One plausible explanation is that it was always expected that the non-custodian, the secondary custodian, would directly bear some of those expenses, that person would get some Happy Meals and some tennis shoes, some show tickets, whatever. On that theory, a custodial parent could ask for a deviation, and that word has been banished. They are now called adjustments, upward, an upward adjustment, if the non-custodian did not actually take little Johnny often enough to actually directly spend some money on the child. Now, it might be surprising for some people to hear, but that common sense perspective was hotly debated back in the day. There was one prior domestic relations referee who argued that the child support statutes had a zero contribution basis, that you should presume, if there's a child support award, that the other side is providing not a dime. And that referee would never increase guideline support, even if the non-custodian never expended a dime on the child directly. In my experience, I think litigators should keep that argument handy and at least request adjustment upward if there is little or no direct expenditure by the other parent on a subject child. And that brings us to a perennial and obvious problem in child support law as it relates to parenting time, which is the focus of this session. If money is involved at all, and it's dependent on the timeshare, then parents and their lawyers tend to be tempted to argue about the timeshare as a proxy battle over the money. There's a lot of questions about how this reality should be reflected in child support regulations and litigation. There's a thought that if you could get rid of the connection between custodial time and money, the parents would really only fight about time if time was important to them and their child. It's an unproven theory, since there doesn't seem to be a way that anybody has come up with to separate the two. But there are questions about how the reality of the proxy battles should be reflected in the child support regulations and litigation, what can be done to mitigate it. For example, should any offset that is permitted by the rules correspond to the written order, or should it reflect the reality of the actual timeshare if that's different from the written order? There are actually people on both sides of that question. Orders that, well, there are judges who have ruled that it's not a change of circumstance if the parents are not actually doing what their child custody orders say they are doing. Orders like that tend to have the effect of preserving a child support order, which is based on false facts. Now, the flip side to that argument is that courts don't want to have constant litigation every time there's some variation in a work schedule or a pickup or a drop-off time. So the issue really should come down to the threshold of change from written order to reality, beyond which a court should be obligated to alter a written child support order. And right now, there's no solid guidance anywhere as to what that threshold should be. But with some cases currently in litigation, it's hoped that some guidance may come out on that issue soon. A related issue is the perennial fight over abatements for extended visitation. Here's the scenario. If little Johnny is with dad for most of the summer, should dad still be paying mom the same amount of child support? And that question brings us back to the fights in Barbagallo and Anastasis. And there is no perfect answer to the questions. The studies, the literature, seem to indicate that the primary parent's expenses are not reliably lower during extended time with the other parent. However, the case could be made that in balancing equities, the welfare of the child would be enhanced if the secondary parent could divert resources that otherwise are being sent to the primary home directly on the child. At the moment, there's nothing in Nevada's formal law that resolves the dispute. So it remains an area where creative counsel should ask to fashion orders they think will serve the best interest of the children involved. We should probably focus a bit more on the ongoing struggles about how to measure time. By my count, there were at least 4 Ely comedy skits on this subject. I know that's a peculiar measure of what issues are intractable, but in my experience, it is a peculiarly reliable one. There have also been several articles, printed articles, out on the subject, some of which are recounted in the written materials. Nevada is not like most states. In most states, parenting time is measured according to more objective, although sometimes less appropriate, measures for how to count time, such as overnights or meals or other criteria. But Rivero requires measuring parental responsibility, which unfortunately has created some opportunities for mischief. Specifically, some litigators and some courts have taken to creative labeling to manipulate child support orders indirectly. The materials include a mathematical example of one way in which this can be done, but the point is that child support can be altered in Nevada by simply deeming one parent or the other responsible for a child during times when, no matter what the court says, the kid will be doing exactly the same thing, exactly the same way. Like being in school from 8 to 3, Monday through Friday. If you alter the label of responsibility during that time, you can completely change the child support order without actually changing what the parties are doing on the ground relating to custody. I don't have a solution for that problem, but it is a good idea for lawyers to keep a lookout for game playing with custodial designations that can be used to alter a child support order that actually might be more appropriate for the actual custodial relationship. Any discussion of parenting time effects on child support leads to consideration, and lawyers should watch for it, of what's called the cliff effect. Now, there's a lot of places in family law where we see cliff effect. Take the situation of traditional military retirement benefits. That's the classic example. If you do 20 years of military service, you get a full pension for the rest of your life. But if you do less than 20 years, you get nothing. Actually, that used to be true. It's no longer true. It's been changed under the new blended retirement system, but that's a separate discussion. But that's an example of cliff vesting. If you satisfy it, you get this very big thing. If you don't satisfy it, you get nothing. Applied to the world of child support and parenting time, the question is whether there's some kind of threshold of parenting time beyond which support that otherwise would be payable changes. And if so, at what point and how much? Nevada falls on the severe side of this issue. When the non-primary parent reaches a 40% timeshare, 146 days per year per Rivero, the change is huge. In fact, as noted earlier, because child support can flow uphill to the lesser time parent, reaching the Nevada cliff effect threshold could completely reverse child support if the parent's incomes are set up to permit it. This huge cliff effect can and does, in real world cases, foment a great deal of litigation over whether parents do or do not reach that cliff. So a couple of questions are presented. First, can we do anything about this? And if we can, should we? And if so, what? There are several possible answers. The materials discuss approaches taken in other jurisdictions, which could be adapted here. Some places have tried to ameliorate the incentive to litigation by building in smaller steps, additional timeshare points where child support is affected by the changes in the parenting time allocation. For example, some parents have, some places, some states have 3 or 4 such steps, and some places up to 8 or 9, where child support alters depending upon parenting time. If you graph those jurisdictions out, the cliff that Nevada produces starts looking more like a staircase, with each increase in custodial time corresponding to a nibble taken out of the child support that otherwise would be payable. Now, as with everything else in the relationship between parenting time and child support, there is no free lunch on the cliff effect subject. First, and most obviously, the more step downs you have, the more complicated the calculations get for every single child support and custody case, which increases the transactional cost of completing every case to some degree. Second, and perhaps more seriously, what is the impact on the adequacy of child support if every incremental increase in parenting time reduces child support to the primary parent, since we don't have an income shares type child support formula? That was the caution in Barbagallo, and it remains a danger of any proposal that would incrementally reduce child support for minor increases in parenting time. As detailed in the materials, the mathematics of alleviating the cliff effect can pretty quickly get pretty extreme. In some places, it requires a computer program to figure out. The lesson is that while eliminating the cliff is attractive on equitable grounds, it presents its own dangers, and both the commission and the courts should tread with care in this area with a view toward unexpected consequences. Now, there are other approaches to modifying support to reflect custodial timeshares. Other ways of playing with the concept of parenting time as a method of producing modifications of child support. Some places have chosen to categorize expenses. One popular triad is variable expenses, meaning expenses which alter with the child's location, like food; duplicated expenses, which are things like housing; and non-duplicated fixed expenses, which is a fancy term for stuff like clothing or things that a child may only need to get in one place and then could have in both places. Those jurisdictions might give a parent who spends just a little time with the child a little break based on the presumed direct expenditures on Happy Meals, but only give major modifications when the parenting time reaches a point where the folks putting together the rules believe that the non-primary parent would likely be paying directly for things in other categories. To my review of the literature, pretty much all of the groupings and all of the timeshare cutoffs for child support abatements for those groupings appear to be pretty arbitrary. And every one of them produced a cliff effect for satisfaction or non-satisfaction. In about 5 or 6 states around the US today, with different child support schemes than a Wisconsin model like ours, they have a sliding scale of direct percentage reduction of guideline child support for each increment in parent time increase. Some places even call it a per diem reduction. If anyone does try to look at this, I urge caution. My review is that most literature is not really apples to apples from state to state. Even when those doing the studies claim that they are doing an apples to apples comparison, because they don't look at the detail of the underlying child support statutes in the various states, which can and do hide a host of details that alter the calculations or blur them or even reverse them. And all of this is a lead up to the multifamily complexity. If that wasn't complicated enough, everything gets an order of magnitude more difficult once you have a multifamily situation. Situations where at least one parent has an X and perhaps child with that X, which according to the literature has become the norm in this country over the course of the last 30 years. And if anything, the advent and increase of fairly new things, same-sex relationships, surrogacy, non-marital relationships, should be expected to make this complexity even more common going forward. The question really is how our regulations and courts deal with child support when each parent has one or more children from other relationships who sometimes share resources in their homes. Ignoring the existence and financial realities of those kids risks basing our child support awards on false assumptions, but directly considering them can make people responsible for supporting other people's children, or unfairly increase or decrease awards outside the scope of the relationship that's actually before the court. So how should courts treat the question of parenting time when the reality is that child custody is essentially triangular among 3 houses or even more complicated? Should our Wright versus Osborne offsets take into account a third party exercising parenting time? And if so, how? As I recounted in the materials, Nevada child support law does not really address these questions. There's nothing in our current child support regulations touching them. But if the literature is correct, distortion effects from the reality of altered custody regimes will continue to increase, and we should probably be prepared to face those realities when fashioning child support orders. Perhaps some category of residual adjustment factors should be reserved for that kind of complication. It can be argued that the support of others factor is broad enough to do so, but given the variety of fact patterns, I'm not entirely sure on that point. The bottom line to all of this is that we still have a ways to go in making our child support laws reflect reality while providing for predictability, adequacy, and fairness, which is the goal of our child support statutes and regs. We still need some development of the law about how to measure time. We should approach tinkering with offsets and cliff effects with caution so as not to create more problems than we are solving. Serious consideration should be given to a first mortgage approach, where a previously existing support obligation reduces the income considered to be available for later support orders. But later obligations can't be used to reduce those previously existing obligations. All told, Nevada child support is still a work in progress, and there is still a lot of room for both improvement and creative lawyering. And that's what keeps it fun. Thank you very much for the time.